Hello, everybody. Welcome. Thank you, everyone, so much for coming. My name is Alicia Varani. I'm the director of the Criminal Justice Program here, and we're really excited to be co-sponsoring this event today. First, we want to acknowledge that that UCLA School of Law acknowledges our presence on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. So as I said, we're very excited to be co-sponsoring this event, showcasing Professor Devon Carbado's new book, one of two new books, Unreasonable, Black Lives, Police Power, and the Fourth Amendment. In conversation today with Professor Carbado are UCLA law professors Cheryl Harris and Beth Colgan. This event is a collaboration between the Criminal Justice Program, the Critical Race Studies Program, and the Office of Public Interest Law and Policy. Thank you so much to the staff of all of those programs who made this event possible today, and thank you all for being here. I will just pass it over to Professor Carbado to kick us off.
Great, so thank you very much for that introduction, and I too would like to thank the programs that are co-sponsoring the event, the PIL program, the Criminal Justice Program, and the Critical Race Studies Program, and all the staff who do tremendous work behind the scenes to make events like this possible. I'd also like to thank our fabulous vice deans, Beth Colgan and Cheryl Harris, both of whom have graciously agreed to be commentators for this particular session. So I'm looking forward to their questions and comments. I hope they're not too hard, but they will be because I invited them, so I can't really complain. Thank all of you as well for showing up, particularly because you come here before the food and the food is awaiting you, so thanks for your presence. Thank you as well to my spouse who's indulged far too many conversations about the Fourth Amendment, and indeed, watching any particular random show might preemptively say, no, House of Dragons is not about the Fourth Amendment. And finally, I'd like to thank my parents, both of whom are now deceased, but whose negotiation of race in post-colonial Jamaica and in the UK certainly shaped my own sensibilities, so I know they're here with us in this particular moment. So what I thought I might do after all those thank yous, you might think that I'm about to receive some kind of award, but I don't have an Academy Award, it's just really the book, is give you a sense of what motivated me to write this book, and give you a sense as well as to the arguments that underwrite it B. The motivations for writing the book are really threefold. First, I wanted to push back against a dominant frame for understanding race and policing that roughly goes something like this. Problems of race and policing might be understood by focusing on individual bad police officers who engage in racialized policing against individual black people. That's the frame, and I want to suggest, perhaps not surprisingly to this crowd, that the problem is a structural one, and I'll articulate precisely what I mean by that presently. Secondly, I wanted to push back against the sense that problems of race and policing are fundamentally problems of illegality, problems of rogue cops, problems of police officers acting outside of the permissible boundaries of law. What I want to argue instead is that many problems of race and policing are problems of legality, problems of police officers acting within the boundaries of law. Indeed, we might even say that there are rule of law problems. And finally, I want to reveal the specific role that Fourth Amendment law plays in all of this. So I want to start at the beginning by offering an account of how we might think about police violence, racialized police violence specifically, as a structural problem. And I think you might understand that anytime one argues that this or that thing is structural, it can be something of a conversation stopper, particularly at the dinner party. So people will say that it's too unspecified, A, on the one hand, or on the other hand, it's too radical an idea to take seriously. So I want to begin our conversation of race and structural police violence by enlisting the help of Tina Turner in the following sense. So Tina Turner's rendition of Proud Mary, where she says we'll begin nice and easy. So let's begin our conversation of race and police violence from a structural frame, nice and easy, by turning to feminism. So you've heard the line, women are not born women, they become women. You've heard that particular line. It's intended, of course, to speak to the social construction of gender. It seems to me that one might articulate a similar line with respect to police officers. Police officers are not born police officers, they become police officers. And having that line in place, it seems to me, invites us to think about police power, and more specifically still, the various sources of police power through which police officers come into being. Increasingly, thankfully, people are reminding us of the relationship between historical police power in the form of, say, slave patrols, or social police power, or political police power. I'm quite interested in thinking about legalized police power by way of the Fourth Amendment. And the slide that you're looking at now is just one indication of the different forms of power through and on which police officers come into being. Police officers are not police officers outside of these particular forms of power. So you can pause and ask whether any of this might, at least marginally, be relevant to debates about abolitionism. Surely we could have an argument about whether, to what extent, this particular police officer in this particular slide, for example, might be disappeared. So do we, for example, scratch this officer out? Or whether we might eliminate qualified immunity, or the no-knock warrants, or traffic stops. Each of these are ways in which you might think about abolishing different forms of police power. But I want to step back just a little bit and ask whether we can situate even debates about the Fourth Amendment in the context of a broader overarching frame. So the overarching frame that I want us to think about starts with the following two observations. The two observations go something like this. Repeated police interactions exposes you to the possibility of violence. If you're not having contact with the police, presumably they can't kill you. If you find yourself repeatedly in contact with the police, that creates conditions of possibility for death. So it seems to me that a big question that we need to ask with respect to race and police violence is this. What are the social forces that stages interactions between police officers and black people as an initial matter? So that's one structural question we might take up. Clearly we need to think about police self-governance as well. If police culture encourages police violence, presumably that's what you will see. If police trainings disattend police violence, presumably that's what you will see. And if police unions are more bent on protecting police officers than holding them accountable, presumably that's what you will see. Note that I've said nothing yet about individual bad cops. The problem is broader than that. And indeed, we might broaden that understanding by asking something like the following question. So assume that an act of police violence has occurred. Everyone agreed that this particular officer is engaged in this particular act of violence, let's say. How do those acts of police violence get processed in the legal system? Police violence plus the legal system equals what? One outcome is justifiable force. You have a police violence moment, it interacts with the legal system, and it comes out as justifiable force. And there are a number of ways in which we can articulate that with more specificity. Think about prosecutorial power. The prosecutor's decision not to bring charges is a moment in which police violence plus the legal system equals justifiable cause. I'm tempted to ask you, name that case and get some kind of response, but I won't do that. We could move now to grand jury power. So the prosecutor decides to bring charges, but the grand jury refuses to issue an indictment. Again, I could say, name that case. This too is a moment in which violence has happened, it enters the legal system, and the output is justifiable force. We could think about jury power or judicial power in the sense that the trier of fact now concludes, after the grand jury has decided to pursue charges, the prosecutor decided to pursue charges, the grand jury issues an indictment, and the trier of fact says it's reasonable. The broader point I'm making is that all of these are moments in which police violence has happened. It enters the legal system, and it comes out as justifiable force. Still, another dynamic is qualified immunity. By now, you all know something about qualified immunity. I'm not going to say much about it here. Our colleague Joanna Schwartz has written compellingly about it. If I start talking about qualified immunity, you might be saying, come back, Devon, and I won't be able to come back. So I'm not going to get into that hole. All I will say, and this is not particularly controversial, is that qualified immunity erects a pretty high bar to holding police officers accountable for the act of violence in which they engage. The debate is not on that descriptive claim. The debate is about, is that a good thing? Is that a bad thing? Not about whether it is a thing. It is. Indemnification, you might understand, occurs this way. So you manage somehow to win a case against a police officer, and the officer pays nothing. The city or municipality pays for the damages. Another dynamic that is relevant here with this police violence plus the legal system equals what? Is you cannot hold police departments liable for the acts of violence in which the officers engage. It's just enormously difficult to do so. A police department would literally have to have some kind of express policy that says, let's go get the black people. I mean, you wouldn't just call it a racist police department, you'd call that, I think, a stupid police department, but kind of announcing its racism up front. But it's something like that standard that one needs to meet in order to hold police departments accountable. We care about each of these factors, I think, because if police officers know at the front end of their policing that at the back end they're going to benefit from justifiable force, they're going to benefit from qualified immunity, they're going to benefit from indemnification, they're going to benefit from the fact that the department won't be held accountable, it creates a disincentive for officers to exercise care. And this disincentive is not about an individual officer, it's about an institutional culture. So I've said that in thinking about police violence, it's important for us to ask this kind of prior question. What are some of the social forces that stages contact between black people, for example, and the police? You can come up with your own list. Presumably it would include some of these: segregation, de facto segregation, which concentrates people in economically depressed areas, which then become available for the war on drugs and the war on crime. Don't think I'm saying anything new here. We can think about gentrification, which is a project of clearing the ground, disposing some bodies, entering others, and the bodies that enter need to, quote unquote, be safe. Policing is a project that facilitates both the displacement of some people, i.e. black and brown people, the entrance of others, i.e. whites, and the need for policing to facilitate that project, A, and to create a sense of safety, B. Or predatory policing. Beth Colgan's work speaks compellingly on this particular point, and the ways in which fees and fines are used to incentivize particular forms of policing that targets economically and racially marginalized groups. We could also talk about mass criminalization, or the criminalization of relatively non-serious activity. The more you criminalize behavior in which many people might engage, the more power that extends to police officers. In other words, police officers leave the station already with probable cause. Or you could talk about biases, or the fact of blackness operating as a suspect classification. You could talk about all of these things, which I'm not going to, which is a little disingenuous since I kind of just did. What I want to focus instead on is the Fourth Amendment. So what role does Fourth Amendment law play in all of this? So I'm curious, how many of you are taking constitutional criminal procedure now? Some of you are. So it's a mandatory course at the law school. You all have to take it before you graduate. That's not really. But you should have laughed. I wanted to really instantiating that point. These are enrollment points. Anyway, it's not a mandatory course, quite clearly. So constitutional criminal procedure focuses on the constitutional constraints placed on police investigatory practices. In other words, the question the court presents is this: what does the Constitution say about the terms upon which the police can engage us in our life? That's the central question, and this is what the Fourth Amendment says. So the Fourth Amendment protects us from unreasonable searches and seizures. Those are the analytical buzzwords. And you can distill those buzzwords into two broad questions that drive Fourth Amendment jurisprudence. Question one is there a search or seizure to begin with? If the governmental conduct in question is not a search, is not a seizure, the Fourth Amendment isn't triggered. So as you might imagine, there are huge contestations in the case law about whether this or that form of police conduct is a search or seizure. To be clear, If it's not a search or seizure, it exists beyond the regulatory reach of the Fourth Amendment, which is to say, police officers can engage in that conduct without any justification. Everyone with me on that? Because we need to understand that before I can proceed. The second big question is, assuming that what you have is a search or seizure, it doesn't mean that the conduct violates the Fourth Amendment. The Fourth Amendment doesn't prohibit searches and seizures writ large, it prohibits unreasonable one. So there are huge contestations about whether this or that search or seizure is unreasonable. The central claim the book advances is that the Supreme Court's repeated conclusions that this or that police conduct is not a search or seizure creates plenty of moments for police officers to interact with people without any justification. The corollary claim is the Supreme Court's repeated conclusions that this or that search and seizure is reasonable creates plenty of moments for police officers to interact with people from the vantage point that those interactions are reasonable. Those are the twin claims, and I unpack those claims in these 7 chapters. I'm not going to go through them in much detail, so I want to speed chapterize just in the following sense. Not as well just chapterize, but indulge it. So chapter 1 focuses specifically on pedestrian checks. The basic idea is this: how does Fourth Amendment govern interactions with people on the street? Hello, what's your name? Where are you going? What's your name? Can I search your bag, etc.? How does the court respond to those kinds of inquiries? What's the court's analysis for thinking about whether someone is seized? This is a doctrinal test. Don't say I didn't give you anything. Learn this. It's on the bar, always on the bar. The test for a seizure is whether a reasonable person feels free to leave or otherwise terminate the encounter. Who is the reasonable person? How does the court understand that? How does the court think about our power to exit those particular interactions? The bottom line claim that I make is this: A, the court really doesn't think about race in the context of analyzing who is or not seized. Should we think about the reasonable black person or not? I don't actually argue that the seizure test should internalize blackness in this way, by the way. To find out what I really argue, you need to read the book. The point I want to make is that the court does not take into account the extent to which biases might shape who police target. The structural forces that I mentioned before might shape who police target, and people's sense of freedom in the context of police interactions could be shaped by race. Significantly, almost every case in which the court concludes that a seizure or a search has not occurred include litigants who are black, on the one hand. On the other hand, the court doesn't even gesture in the direction of thinking about what those racial experiences might look like. So this is the moment in which we might trade on Toni Morrison's observation about on the backs of black. So the jurisprudence trades to some extent on the fact that the litigants are black, but doesn't really engage them. With respect to chapter 2, the focus is on traffic stops. And the easiest way to summarize the story of that chapter is by way of a case, Wren versus United States, whose facts might go something like this. So assume that I'm driving down Westwood Boulevard and I violate a traffic code. Assume that Beth Colgan does the same thing. Beth probably drives more carefully than I do, but just let's stipulate that she violates a traffic infraction too. 2 cops observe both of us violate this traffic code. No dispute about that. Cop 1 says to cop 2, look, we can't stop both of them. Let's stop the black person. And for purposes of this exercise, let's stipulate that I am the black person, not Beth. So the cop stops me, and I want to say that's unconstitutional. I lose that argument based on a unanimous opinion, Wren versus United States. So the chapter tells the story of that particular case and explains why it's wrong. Stop and frisk. The bottom line point I make in this particular chapter is this: that A, Justice Warren, the man who writes Brown versus Board of Education, opens the door to stop and frisk in 1968 in a case called Terry versus Ohio. B, he does so in a way that departs from probable cause and introduces a new standard, reasonable suspicion. The court doesn't actually use reasonable suspicion, but that's roughly the term that is used in that case. And C, it's a low evidentiary bar, which means that police officers have license to stop and frisk people on the thinnest of justification. Justice Sunita Patel, who actually participated in the New York litigation on this particular point and secured a major victory that delegitimized the extent to which NYPD officers were violating even this thinnest of justification. Because the point that I make is that even when officers act within the boundaries of stop and frisk, we should be concerned. Chapter 4, Stop and Frisk, is really just a story about the ways in which the reasonable suspicion standard has been applied to a number of different domains, including to justify sexual violence against Black and brown women at the border. So that particular dimension of state violence doesn't seem to enter our consciousness about the ways in which policing operates and the role that Fourth Amendment law plays. Chapter 5 focuses again on predatory policing. It's a Fees and Fides story that Beth has written compellingly about. And chapter 6 is really the story of Ren. It didn't require much of me to write this chapter because I didn't. I just basically included the Ren chapter on the view that everyone should read it. And chapter 7 is a rewrite of that chapter to illustrate the degree to which it wasn't necessary for the court to conclude that the fact that an officer stops me and not Beth is reasonable under the Fourth Amendment. The court could easily have said, this is not a radical argument, that racial profiling is unreasonable. Why is that a radical argument? I mean, I'm looking. Does anyone think that's a radical argument? Would anyone imagine ordinarily that in the domain of Supreme Court jurisprudence, there would be a moment in which the court doesn't conclude that racial profiling is unreasonable? I mean, against the backdrop of the canonical case, Brown versus Board of Education, you would think that would be easy. You think it would be easy to say that stopping me and not Beth is just unreasonable. And yet the court didn't do that. So I'll stop by saying again that I worry about the degree to which the focus on conversations about race and policing is one that individualizes, so that we're focusing on bad cops as distinct from police power. It seems to me if we have police power in mind, it forces us to think about all the different expressions of that power. And we can ask ourselves, do we like some of them or not? But it centralizes debate in the direction of how police officers come into being, rather than a conversation about whether this particular police officer in this particular instance is good or bad. So I'll stop there and turn it over to our terrific commentators to hear what they have to say. Thank you very much.
Thank you, Devon, for inviting me to comment on the book. I really am also thankful to all the organizers that made this happen. So much of what happens in terms of our obligations these days has to do with sitting in meetings. It's actually great to be sitting in one where we get to talk about ideas, and particularly with you. So the book is very elegant and accessible. There's an incredible structure to the book, which makes clear why your teaching, Devon, is so effective, because one can read this book as both a primer and a treatise on Fourth Amendment law, and I invite all of you to do that. If you understand this book, you will understand really a lot about Fourth Amendment law. And if you're not yet doing so as part of criminal procedure, or constitutional criminal procedure, I invite you to do that. I'm really fascinated by your account of policing as a racial naturalization process, by which you allude to the role of policing in marking you, some might say transforming you from a Black West Indian immigrant here in the United States into a Black American. And I know you've written before about this idea of racial naturalization, the ways in which there are social processes and social forces that actually cause people who enter the United States to enter into in a particular location in a racial hierarchy. You describe both a traffic stop, which might be traditionally thought of as driving while Black, and the event that I think of as you making tea while Black, which describes an incident where the police interrogated you and your brothers in your sister's home, actually at gunpoint, apparently as the result of a white neighbor's call that you all seemed racially out of place. So you're in your house, you're making tea, the police arrive at the door with guns and say, "What are you doing here?" All of these really underscore, I think, part of your thesis about the all-encompassing nature of the surveillance, constraint, and violence to Black bodies from the police, and the fact that one event occurred in the street and the other one in the home, I think really makes clear that there is no refuge. There's no sort of safe space in the universe that you describe. I'm particularly interested in the way that you note that your own racial consciousness, though, about policing had not been part of your experience while growing up in England, even as you were very clear that as part of a Black immigrant community there, the practices, police practices, racist police practices were very much part of that environment. And you note, in fact, the riots in Brixton in the early 1980s were a manifestation of that violence, or reactions to that violence. In fact, really interestingly, the period that you mention and describe of these interactions between the West Indian community in London and the police was part of a recent 5-part series, which I highly commend to you all, called Small Acts, by the director, Black British director Steve McQueen. And several of the films in that series deal with that very troubled dynamic. It follows the trial of a novelist who was sentenced to prison following the Brixton uprising, as well as another segment, very intriguingly, something that you've also written about, it's called Red, White, and Blue, which is focused on a young Black man who decides to become a policeman despite the fact that his father has been a victim of police abuse. And you've written about the Black police, which is, I think, really an interesting phenomenon. So as you note, the point being that racialized practices were a part of British life, but yet you describe your quote-unquote veil of ignorance as being more a matter of timing and circumstance, that you were very young when the Brixton riots occurred, and that your departure from England came right at the moment where you would have begun to encounter the world on your own and undoubtedly experience the British version of stop and frisk. So you describe yourself as sort of arriving in this sort of veil of ignorance, or maybe state of innocence about this interaction, and why you were unschooled as to why you need to be deferential to the police in this traffic stop, why you were asking questions that were the kind of questions that you now know to be very dangerous. I think this is really an important reminder that policing and police abuse are a worldwide phenomenon. That is evidenced by the global dimensions of the protests that followed the murder of George Floyd by members of the Minneapolis Police Department, that everywhere there are police, there are credible charges of abuse. And even more specifically, in societies that are riven by racial hierarchies and its legacies, that policing practices and policies are perceived to exacerbate those divisions. And yet you have a really powerful passage on page 6 that really kind of stopped me. And that you note that while not all Black people experience vulnerability to the police in precisely the same way, you note, for example, quote, gender identity, age, location, sexual orientation, immigrant status, and economic background mediate Black people's exposure to the police. Yet, you say, quote, at the same time, none of these factors undoes the historical ways in which the Black body in all its configurations has been the site in which the U.S. has worked out its law and order commitments. Let me read that again. At the same time, none of these factors undoes the historical ways in which the Black body in all its configurations has been the site in which the U.S. has worked out its law and order commitments. And so this observation really provokes some important questions for me about whether or not there is something distinct about the relationship between race and policing in the United States. Your narrative seems to suggest that it does, as does the statement that I just referenced, and that does not mean that other societies like the UK or France do not similarly make their Black residents vulnerable to racialized policing tactics and abuse, but rather where anti-Blackness is a constitutive dimension of law and order, does that produce some particular features of the problem here? Does that sort of raise a different kind of, sort of in the same vein, but a different vector to some dimensions of the question? Another powerful dimension of your book is your explication of the shortcomings of law, as you just did, in reducing the matter of racialized violence to individual conduct when the problem is structural. And what I think is particularly illuminating is how you connect and relate the narrative of your individual encounters and other individual encounters to the structure of policing, which, as you indicate, is undergirded by law and specifically by the Fourth Amendment, which has been inverted from a constitutional safeguard against police power to a virtually unchecked authorization of the exercise of that power. And I think that's really, for me, a central thesis of the book, that indeed the valence of the Fourth Amendment has been flipped entirely. And further, that under the current framework, the cases devolve into questions, as you note, of individual liability, that considers the individual conduct of police versus the conduct and character of the victim instead of the structural dimensions of the problem. And your deconstruction of what you mean by structural, to my mind, offers a nearly irrefutable account of your thesis. So in that chapter, you go through segment by segment what you mean by structural, and I think that deconstruction is really very helpful. In many ways, the problem that you're identifying, describing of how law disaggregates structural problems into matters of individual conduct, really mirrors broader debates in anti-discrimination law and the continued constraints placed by current doctrine on structural analysis as well as structural remedies. So we could extrapolate this similar critique, that extrapolate your critique into the domain of employment discrimination, into the domain of housing discrimination, etc. But of course, the fact that you're so really clear and convincing regarding the structural nature of this problem, as you point out, leads to a question that your book clearly anticipates and that you've wrestled with, which is if the current structure of the doctrine and of litigation generally does not capture this structural dimension, what is the role of law in litigation? And I think you wisely, on page 34, eschew a traditional move towards a list of prescriptions. As you say, quote, "Too many books end with a chapter that purports to solve the problems the book describes. Not here. For the truth is, not only is there no easy Fourth Amendment fix, but also that the Fourth Amendment is only one of the structural forces shaping the excessive presence of the police in Black people's lives." And you recognize explicitly that the debates over divest, invest, defund, you're saying, you know, this book doesn't specifically sort of enter into that debate or offer solutions about that debate. But I am still intrigued by the ways in which you see your project as pushing beyond the boundaries of traditional modes of law reform. I, for one, certainly see those possibilities and consider that what you have described, that the role of the Fourth Amendment in, quote, allocating power to the police to surveil, racially profile, to stop and frisk, and to kill, as laying the groundwork for something that goes beyond traditional reform. And so taking up the framework of Ruthie Gilmore's and other groundbreaking abolitionists, Ruthie's argument about prison abolition is that it's not just about closing prisons, it's a theory of change. She calls for non-reformist reforms, in which she defines as, quote, changes that at the end of the day unravel rather than widen the net of social control. Reforms that, in other words, facilitate transformation, that build bottom-up democratic participation. Amna Akbar has also talked about non-reformist reforms as well, describing them not as reforms that stand outside of electoral and legislative politics, but that rather may call for a careful engagement with them. Reforms that, quote, deepen consciousness around the violence and exploitation of the status quo as it advances the possibilities of alternatives. So in thinking about this non-reformist reform idea, I'm thinking about the relationship of your work to laws, specifically why engage the courts and the law if they are instruments of legal oppression, and what do non-reformist reforms look like in this arena? So I'll leave it there.
So as you know, I'm Beth Colgan. I just want to say first, I'm very honored to be part of today's discussion. When I came to UCLA several years ago as a junior scholar, Professor Carbado very quickly became a mentor and cherished colleague for me, and so I'm really thrilled to be able to celebrate him and this important book. And just in case you're wondering, I tried to tab out just the super brilliant and not just basic brilliant things, and I ran out of tabs in my this is something that's really worth us having this conversation today. And as someone who studies and teaches about the Fourth Amendment, I can say without a doubt that what he's done in this book is a truly extraordinary accomplishment. This doctrine is very complex. There are moving pieces that never seem to stop shifting. And in the background of it all are people's lives, their liberty, their dignity, and all of that is at stake, even though often the court doesn't seem to recognize that. But somehow Professor Carbado has managed to marshal it all into a comprehensive yet legible account that is once clear and devastating. And importantly, he doesn't let us look away from the fact that race is both ignored by the court and criminalized by it. And by the end of the book, the writing is not just on the page, but on the wall. The Fourth Amendment protects the police, not the people, and especially not Black people and other people who are heavily policed. As Professor Carbado notes, and as Professor Harris just notes, that he says that the book is not intended to offer a silver bullet to this dilemma, though I actually don't think he gives himself enough credit. Interspersed in the pages of the books are offerings about how the court might get things right or at least less wrong. And he actually provides a roadmap for areas of intervention, structural intervention, the kind of non-reformist reforms we just heard mentioned. But it does offer us a challenge. If the Supreme Court is committed to the path it's on, and it seems to be, what else can be done? How might we abolish various forms of police power? So I'm going to focus my comments on that. So first of all, every state Supreme Court has a constitutional provision that mirrors the Fourth Amendment of the U.S. Constitution. This means, with an exception I'll mention in a moment, that state Supreme Courts could interpret their own constitutions to be more protective than the Fourth Amendment under the federal Constitution. Because a state Supreme Court is the final word on the meaning of their own state constitutions, the United States Supreme Court has no power to overrule such a decision. I do want to say, I realize there's a certain historical irony in suggesting that the place to go are state Supreme Courts rather than United States Supreme Courts to protect civil rights, but that's where we are. So here's an example, consent. One of the things that Professor Carbado explains in the book is that consent plays multiple roles in the Fourth Amendment doctrine. The first is that we have the question of whether someone's been seized at all. So as the U.S. Supreme Court has held, if you're on a bus, for example, and law enforcement officers walk down the aisle and ask if they can search your bags or your person, that does not mean you've been seized for purposes of the Fourth Amendment, because a reasonable person, whoever that is, would feel free to terminate the encounter. Second, if you are already seized, say in a traffic stop, then under federal constitutional law, an officer may not unreasonably extend that stop. But if, as the officer is writing out the ticket, she says to you, or says to the driver, "Can I search the vehicle?" something she can do without informing the driver that he can say no, that would not be an unreasonable extension of the stop. And if the driver says yes, the officer now has a justification to extend the stop that's reasonable for purposes of the Fourth Amendment. In 2019, the Oregon Supreme Court interpreted its own constitution to offer much greater protection. The case also involved a traffic stop for failure to use a signal and a lane change violation. And while the person was searching in his glove compartment for his registration, what the Oregon courts refer to as an unavoidable lull, the officer asked for and received consent to search the car, and drugs were found. Now, under U.S. Supreme Court precedent, those drugs were found legally and can come into evidence. After all, the officer didn't unreasonably extend the stop. He just used the time that the person was taking to get the registration out of their glove box to his advantage. But the Oregon Supreme Court saw the situation differently. It agreed with the prosecution that asking for consent wasn't itself a seizure. That's just like the bus case from the U.S. Supreme Court. But it said that once a person is stopped, the request for consent has constitutional significance and must itself be justified. And since the only justification for pulling over the car was the failure to use a signal and improperly changing lanes, the officer's questions during the stop had to be limited to those topics. Asking to search the car had nothing to do with either traffic violation, so under the Oregon Constitution, the officer is prohibited from doing so. In reaching this conclusion, the Oregon Supreme Court expressly noted that absent that rule, officers could engage in pretextual policing, which would not be appropriate. The opinion reads, if we were to hold otherwise, then an officer who lacks a warrant, probable cause, or even reasonable suspicion of criminal activity could stop an individual for minor traffic offense and, during that stop, conduct a criminal investigation anyway, making meaningless the rule which requires an officer to have reasonable suspicion before stopping an individual to conduct a criminal investigation. If only the U.S. Supreme Court was so clear-minded about the realities of the rules it creates. Here's another example, flight. One of the things Professor Carbado discusses in the book is a case called Illinois versus Wardlow, in which the Supreme Court held that if someone flees upon seeing the police, that's suspicious and can contribute toward a determination that the officers had reasonable suspicion or probable cause. As explained in the book, this is both problematic in that it makes suspicious a thing we have a constitutional right to do, walk away from the police when they don't have a justifiable reason to stop us. And it's problematic because when people flee from police, they may be making the entirely rational decision to avoid being caught in the crossfire or to protect themselves against becoming victims of police brutality. In 2016, the Massachusetts Supreme Court took up a case in which the Boston police ordered 2 black men to stop and the men ran away. The Massachusetts court agreed with the United States Supreme Court that when assessing reasonable suspicion or probable cause, the fact that someone runs should be in the totality of circumstances we consider to decide whether their behavior is sufficiently suspicious. But it also said it wasn't going to give it hardly any weight. Let me quote the opinion. First, we perceive a factual irony in consideration of flight as a factor in the reasonable suspicion calculus. Unless reasonable suspicion for a threshold inquiry already exists, our law guards a person's freedom to speak or not speak with a police officer. A person also is under no obligation to respond to a police officer's inquiry. Where a suspect is under no obligation to respond to a police officer's inquiry, we're of the view that flight to avoid that contact should be given little, if any, weight. Otherwise, our longstanding jurisprudence establishing the boundary between consensual and obligatory police encounters will be seriously undermined. The opinion continues by pointing at internal Boston Police Department data showing that black men were being targeted for stop and frisks. The court said, we do not eliminate flight as a factor in the reasonable suspicion analysis whenever a black male is the subject of investigatory stop. However, in such circumstance, flight is not necessarily probative of the suspect's state of mind or consciousness of guilt. Rather, the finding that black males in Boston are disproportionately and repeatedly targeted for police encounters suggests a reason for flight totally unrelated to consciousness of guilt. Such an individual, when approached by the police, might just as easily be motivated by the desire to avoid the recurring indignity of being racially profiled as by the desire to hide criminal activity. So, again, one of the things we can think about is how do we go to other places beside the Supreme Court to think about ways of interrupting the jurisprudence they've created. Another place we might look to is the state house rather than the courthouse. So one of the things that's brilliant about the book is that it talks about how mass criminalization of offenses acts as a structural mechanism for the kinds of harms we see in today's policing. So one of the things we might look at, for example, is traffic violations. In the chapter on traffic stops, Professor Carbado provides a list of just some of the vehicle code violations that could subject a person to a stop, including displaying dazzling lights and a turn signal not given continuously during the last 100 feet before a turn. In fact, there are so many traffic violations on the books that it is nearly impossible to drive a car without violating the law. As one instructor providing training to a police academy recruit has explained, if you're following a car for more than 3 blocks and you haven't found a violation to stop it, you're not looking. So what if we clean the books of all these ticky-tacky little traffic offenses, having air freshener dangling from your rearview mirror, or only having one operating license plate light instead of 2, window tinting? I don't want to pretend this is going to be easy. There would be law enforcement pushback for the very reason that they would lose out on the opportunity to use those traffic violations for pretextual policing. There could be pushback from other entities if we stop requiring biannual smog checks. For example, smog check providers might have something to say. It can also be difficult to separate out traffic laws that have true implications for public safety, like high rates of speeding, from ones that can be used pretextually, like speeding, going 2 miles over the limit, right? But we shouldn't forget, as Professor Carbado describes as well, that cities and towns across the country rely heavily on this revenue to generate money for both public services for all sorts of things, including policing itself. But it could have significant impacts if we were to actually take some of those offenses off the books. So far, so good. What might the unintended consequences be? Well, one of them is detailed in the chapter on predatory policing, in which he talks about fines, fees, and forfeitures. One of the things we know might happen is basically like a crazy game of whack-a-mole, where if you clean up one area of the books, it can push policing into other areas that are still there. And traffic law isn't the only place where we saw an extreme expansion of policing. Broken windows policing led to a variety of all sorts of minor offenses. Take selling loose cigarettes, which was the crime at issue when the officers choked Eric Garner to death, right? So just as it's very, very easy to police under the Fourth Amendment in the traffic context, those exact same rules apply everywhere else, which means that the officers have all sorts of reasons to just shift policing. And they have reasons to do that in part because, one, they're going to potentially be pressured by municipal and state officials to generate ticketing revenue if they can't do it through traffic ticketing. And two, that gives them an opportunity to engage in civil forfeiture practices whereby they can take people's cash and property without charging them for an offense. And that money, often they get to keep. And so we've seen this happen. So after the public outcry in Ferguson, Missouri, state officials began enforcing a longstanding statutory cap on the percentage of municipal revenue from traffic fines. The city of Pagedale, which had previously been highly dependent on traffic fine revenue, began ticketing all non-traffic offense violations, such as having unmowed grass or having toys in one's front yard. Those violations went up 500%. So as with traffic enforcement, the enforcement of public order and low-level offenses We could clean those off the books. Is that going to fix the problem? No, but it could help. But what we do know is that this all ties into a variety of other things that have long been used to subjugate Black and brown people in particular, including the war on drugs. Drug legalization raises complex issues involving the availability of public health responses to addiction, the creation of safe injection sites, the increased risk of overdose caused by the introduction of fentanyl, and more. But if we're serious about reducing police violence and thinking about the structural ways we can undermine the Fourth Amendment doctrine this court has created, that has to be taken seriously. So let me very briefly return to Professor Carbado's book. It makes so many important contributions, including making the Supreme Court's Fourth Amendment jurisprudence legible to lawyers in training, and non-lawyers alike. But it also helps us understand that by creating a doctrine interpreting an amendment designed to protect the people from unreasonable searches and seizures, and interpreting it so that it instead protects police, the Supreme Court has abdicated its responsibility for protection of the people to the state courts and the state house. There's no guarantee that justice can be found in either of those two places, but it is possible. So with that, I will stop and turn things over.
Great. Well, join me thanking them both for those comments. So I'm really hoping at least to hear preliminary from you. I'll react very quickly to some of what the very thoughtful questions and comments embedded in what you've heard. I mean, to begin with, Cheryl Harris's point about history, policing, comparative racialization. So I do think there are differences between the US and the UK, let's say, that the book doesn't really go into, that has precisely to do with the role policing historically has played in the state, in the US. So again, increasingly scholars are sort of mapping that terrain from slave patrols to Reconstruction to policing the color line to war on drugs, etc. And I think we're learning more and more about some of those continuities and what they might mean in the contemporary context. Policing in the UK, for example, don't have precisely those entailments because the project of race was managed, not entirely, but significantly in the colonies, as it were, in the other place, rather than in the UK as well. And one always has to be careful about how strongly one articulates that point, because there have been non-whites in the UK for a very long time who've been navigating different dimensions of British rule and its entanglements with race. With respect to the law reform, I mean, I really do punt in the book, I think it's fair to say, on how to think about, you know, abolitionism, non-reformist reform, etc. I don't say an awful lot about that. Part of what I'm trying to do, I think, and this did not please the press, was I did perform a little bit of a bait and switch. I said, look, I'm going to write this book, I'm going to tell you how to fix it. I don't tell how to fix any problem. But my thinking really is this. If you did a search on Westlaw, go and do a search, and you look and you compare, for example, how many times do you see racial profiling? How many times do you see qualified immunity? How many times do you see stop and frisk? And juxtapose it against how many times you see the Fourth Amendment, you would be shocked. By that I mean, some of the most pressing discussions that we have about race and policing are not ones within which the Fourth Amendment figures at all. So I see this book largely as a consciousness-raising project about the degree to which our understanding of race and policing should understand this as just one side of power that might have entailments about where we direct our reformism or non-reformist reformism or abolitionism, whatever one's individual preferences might be. And in that regard, Beth Colgan's unpacking of some of what state courts are doing becomes particularly crucial. If we were to tell the story, for example, about what has happened in the domain of LGBTQ T rights over the past decade, it's not a story about the Supreme Court leading the charge. It's a story that begins with a company, a municipality, a state, and finally the Supreme Court sort of catches up. Not in the most robust way that one might want, but all of this is to say that that embedded in that story, it seems to me, is a recognition of different sites for social change. And the final thing I want to say, and I should say this loudly and clearly and loudly and clearly and loudly and clearly, that it's not my view that law is the most important game in town vis-a-vis any discussion of inequality. But it is my view that law is a particularly important game in town. And we can just think about that game by asking ourselves questions about the Supreme Court's last term. I mean, who's going to say that law doesn't matter against that? Indeed, I think it's fair to say that this year is one in which the Supreme Court is on everyone's mind in perhaps a way it hasn't been for a long time. And part of what I suggest, I think, is that cases like Wren should be a battle cry, in the way that cases like Roe, for some people, is. So lots of cases that have done enormous harm from my vantage point, circumscribing the opportunity for racial remediation, that are not battle cries for social change more generally. So I'll stop there, and maybe we can take questions or comments that people might have.
Questions?
Yes.
Yeah, this is a kind of a difficult question that I think I'll line up, so it's fair if there's not really an answer, but I think about it in terms of like, disempowering the police and their unions to an extent, to a large extent. Just what are the first steps there? Because they don't, as you seen like last week, the, LA sheriff civilian oversight board, they went in ahead and are harassing those members of that board for not taking a stand against them. I don't think, in NYPD, repeatedly harassing the de Blasio family, particularly Chiara de Blasio. They're not afraid to go outside the bounds of the law to intimidate, people, civilian politicians who are willing to take an active stand against them. So what are the steps to eliminating the police's, not eliminating, lessening them as a political and paramilitary force if there's no countervailing force?
Well, look, I think I think everyone should weigh in on this. I mean, I think my view is that so part of it is understanding, first of all, what the sources of power are, because I think it's those sources of power that helped to create a certain kind of social traction outside of formal legal power. To put that another way still, I mean, it's not just the case that we're confronted with a scenario in which how police officers act is mediated by rules of law, though that's clearly an important part of it. It's also true that how police officers act is mediated by the kind of role police officers have in society. So I think the more one can at least stage conversations about what do we think the permissible boundaries of that power should be, the more we're in a place to grapple with those kinds of questions. What you say as well quite clearly implicates broader issues of dissent. To what extent is it the case that certain forms of dissent are deemed to be more permissible, more in line with how we understand a democratic order, and other kinds of dissent not so much? So I think there's a broader question about how we think about dissent and resistance that are embroiled in law enforcement imperatives that we're only now beginning to grapple with. Other comments or questions? Yeah.
Thank you. I'm having flashbacks to my time with you in constitutional criminal procedure.
I don't mean to do that, sorry.
No, in a good way. I was actually here on time back then. I'm thinking about kind of taking a futuristic view. As technology adapts, as the kind of panoptic capacity of the state to surveil and understand what we're doing and what we want and what we're looking for, it continues to expand. How do you see the police power either expanding or constraining? Is there some kind of natural stopping point, you think, in which police power can interrogate Black lives and Black livelihoods? And do you think the Fourth Amendment is
So I think that's a terrific question, and I'm hoping that
Sure.
Vice Dean Colgan would also weigh in, given that she's been teaching some of these cases this term. So here's one way to answer that question. There's a weird, weird is the wrong word. One can be crude and think about Supreme Court decision making, particularly in the context of Fourth Amendment law, and say that what you see in effect is a question of externality. By that I mean, to the extent that Supreme Court justices can externalize the cost, then chances are they're not going to rein in police power. If they think instead that the particular incursion implicates their lives, it's another story. So if you think of some of the technology cases, Exhibit A would be the cell phone case. What's the name of that case?
Well, there's Riley and Carpenter.
Yeah, right. So,
Yeah.
so where the question becomes, what kind of justification is necessary to get inside your phone? An awful lot, because justices have phones. What kind of justification is necessary to get inside a bus and question people while they're on public transport? Not a lot, because justices don't take bus. I'm being crude about it, but I think there's a question embedded here about the degree to which technology impacts ways of living that justices see themselves implicated in, that will do some boundary work, and you see that at least at the margins in the current technology cases. But there are other places where you won't see that. So helicopters, surveillance, that's all good. I mean, trying to curb that kind of practice, justices are not necessarily worried about that. So it depends on the particular kind of technology, its mobilization in public life, that you might see some boundaries or not. So that's sort of a real politic answer in a way, but I think there's something to it.
Mm-hmm. Yeah, I would just quickly add to that. I do think it's a place where the court is very uncomfortable with its own doctrine, is with new technologies. So for those of you who haven't taken criminal procedure, that sort of a test to determine whether there's been outside of seizing a person, one of the tests for deciding whether there's been a seizure is whether there's a reasonable expectation of privacy. And there isn't if you've knowingly exposed information to a third party or if it's happening in a public space. And which is everything you do on your phone is knowingly exposed to a third party, right? This is a GPS device, so anywhere you go is in a public space. This is tracking it, and so but the court has actually said yes, those rules generally are the rules, but when it comes to technology that could create a mosaic of your life that tells the government too much, that's too much power. And so we're going to say actually that is a search, and you either need a warrant or an exception to the warrant requirement to do it. And to the point Professor Carbado just made, they really do seem to care that it could apply to them. One of the justices in one of the arguments on this case said, "You mean you could track us?" That was one of the questions at oral argument. I would guess that question didn't come up in any of the bus cases, though I haven't read those transcripts, so I'll have to double check. But so it is actually a place where there may be some room for Fourth Amendment growth in protection, but one of the issues is that the cases are lagging behind the technology. So there's all sorts of technologies that are being used that haven't yet been challenged, in part because we don't know they're being used, right? So that's a real trick in this area, and that is going to have implications for anyone that's in the system already. But one other place it's going to have implications in is DNA collection, which for those of you who are in my class coming up, we're going to be studying soon. But there are things like recently there's been an effort to try to get DNA of Black people who might be associated with or the descendant of someone who's been found in mass grave sites in Oklahoma and other places in the South to try to identify who they might be, because but it's government collecting your DNA, and there's no limitation on what they can use it for once they have it. So, so there's things like that where technology is expanding so quickly that it's really tricky to see how any court can keep up with it without damage being done.
There's a question? Yes.
Yeah, so this has been so fascinating. Thank you so much for having this talk. I'm excited to read the book. I think I'm curious about what all of this means for individual practitioners. So like for those of us who are interested in public defense, for instance, like there is this framework that is imposed on us that we have to operate in. And so I guess what tools do we have to either push back or step outside of communities, work with civil rights activists? Are there other tools you might suggest for practitioners kind of on the ground?
Yes, interestingly, it's a strange moment in which we find ourselves vis-a-vis that question. So I have been engaged by a number of practitioners on ways to think about incorporating concerns about race into various suppression motions. So lawyers on the ground are actually making these kinds of arguments and sometimes winning, precisely because the Supreme Court isn't the only game in town. And even in the context of lower federal courts, people are making arguments that you would think are completely off the table vis-a-vis what the Supreme Court has said. So I think it's really important then, so now I will preach, I didn't come here to preach. It's really important to, A, take very, very seriously the doctrinal terms upon which the court articulates its rules. I'm going to say it one more time. Before you think about staging any fight from whatever your positions might be, understand the logics of Supreme Court adjudication with respect to, now we're talking about criminal procedure. B, think about where your spaces might be to intervene within that, because there are possibilities, they're circumscribed. But if you had told me, for example, a decade ago, that some of these arguments would win in this context, I would say, absolutely not. But these arguments are working precisely because people learn and understand the doctrine well enough to figure out how to do that. The final thing I'll say on that point is that in the context of writing this book, I was sure to share it with people across the ideological perspective to say, tell me that I've gotten the law wrong. Tell me that my account of the doctrine is wrong. And they couldn't, not because I'm some special intellectual, but because I wanted to show that you can expose the racial difficulties through a doctrinal story. So the book is written literally in the form of law school hypotheticals. Imagine this, imagine that, imagine that. How does the Supreme Court apply it? To expose what might be going on and to invite a conversation about some of the narrow spaces doctrinally in the domain of practice where you might intervene.
Let me just quickly say that one of the things he does brilliant in the book is actually use the Socratic method to the reader. So it's not just law school hypotheticals. There's a lot there that really makes the book both interesting and fun.
Yes.
Just now on my mind, I'm guessing that the style of writing is flexible on block titles, and I feel like that's very, very clear legal writing, and I really appreciate it, even though it's like dealing with theoretical things. But anyway, I was just thinking about the interaction between tech and policing and Fourth Amendment and information collection and the limits of the Fourth Amendment in terms of protections that we do have, right? That the issue with having warrants or exceptions to the warrant requirement only have to do with evidentiary concerns for criminal proceedings, right? So other information that is taken from our technology can be used by police, I think, in other ways. So what, do you see potential for Fourth Amendment protection despite, with outside of criminal proceedings, and if not, where can we look within the law to develop those protections with tech moving as fast as it is? I know this is kind of a departure from the book, but also.
It's not a departure in this sense. I mean, part of the difficulty with respect to the content of a Fourth Amendment rights is that they're adjudicated in the context of cases in which the presumption is that the person has done something bad. So if you're a judge, a magistrate, or whatever, and you're deciding, am I going to suppress this gun? The cop found the gun, it must mean that the person did something wrong. So concluding that there isn't a Fourth Amendment problem means that the gun goes out. So the very fact of this hindsight bias, if you like, circumscribes already the scope of a Fourth Amendment right. And indeed, there's a piece by, I think it was Nancy Leong, I may have this right, where she looks at the content of Fourth Amendment rights when they're adjudicated in the civil context versus the criminal context, and there's a difference with respect to the scope of the right. So there is a profound problem there, and it suggests as well that there should be legislative and other kinds of efforts so that Fourth Amendment jurisprudence isn't the game in town vis-a-vis protecting privacy, and indeed people are moving in precisely that kind of direction. Take one last question.
Thank you, and thanks for this. This is incredible. My question relates to what you said earlier about how the Fourth Amendment has come to protect police and kind of view them with additional powers. I was thinking a lot about, the police power in the context of other agencies that may exercise the ability to search a scene, like family regulation systems, like, public housing where you're not entirely entitled to complete privacy in your home. So I'm wondering if there's room for exploration of Fourth Amendment jurisprudence in those areas.
There is. So part of the story the book tells includes precisely those sites. So you might refer to them as the supervisory arm of the criminal justice system. So people on parole, people on probation, that's one dimension for it. But also its intersection with the welfare states, where you might be talking about schools, or you might be talking about public benefits office. So the chapters describe the ways in which people's vulnerability to incursion is shaped precisely by their relationship to those particular domains. So, and, as you might imagine, the story is your privacy is even further compromised at the very moment that you might be in need of state benefits. So it's not a happy story.
And one thing I'll just add to that is that generally speaking, those sites have been seen as within the Fourth Amendment because the people you're talking about are government actors, so the welfare agent, the school principal, et cetera. And up until about 2 or 3 weeks ago, I felt very comfortable in saying that's just the accepted law. There was a lower court opinion recently that said a postal worker who took mail out of someone's box and went through it because they thought the person was engaged in crime was not a government actor, and therefore the Fourth Amendment doesn't apply to them. Makes literally no sense. But that we do now have a lower federal court saying that, and it worries me that if that's taken up, that could start expanding itself into other areas like the welfare worker that's going through someone's apartment. So it's definitely something to be keeping an eye on.
Well, look, thank you all very much again for showing up. You've more than earned your lunch, I must say. So we really enjoyed this opportunity. Enjoy the rest of the day.